Most investors don't realize that their name is sitting on the public records on every property they own, and that creates risk. Not just lawsuits, but there can be targeting, there can be harassment, there can be, and if you get sued, then you get inflated settlement demands because they see properties. And I'll use an example of a client who lived in a decent neighborhood in California. A tenant of theirs trashed their home, flooded it, didn't call the landlord, let that flood become mold, sued the landlord for mold, and throughout the whole ordeal, of course, insurance doesn't cover that type of thing, they said, hey, we know where your client lives, and we think that they can afford to settle. You don't want that, and that is why I brought in an expert, Amanda Wynalda. First off, welcome.
Thank you, Toby.
And Amanda is an expert speaker on this topic, and she works with anonymity all day long with real estate investors. You've been doing this how long?
Over a decade.
Right, and you're an attorney and an investor.
I'm an attorney, an investor, a business owner. I specialize in asset protection and saving tax for investors.
Perfect. So she is an ideal candidate to explain how this actually works. And so Amanda is going to actually be breaking down privacy in using land trusts specifically, and in conjunction with LLCs, we'll get into that too, and how to use it correctly. So let's start really simple here. Who actually needs to hide their ownership in real estate?
That's a great question, Toby, because a lot of people may think, oh, I only have my primary residence, or maybe I have one or two rental properties. These higher level asset protection strategies are for the ultra rich. And that's actually not true, because if you think about your risk analysis, the ultra rich can afford to have a lawsuit. Who can't afford to have a lawsuit? It's the newer investors. It's the people who their biggest asset in their name is their home. And so a single lawsuit can, even if you end up winning, can, in lawyers' fees and court costs, completely wipe you out. So if privacy in this asset protection world is really for everyone.
Yeah, I had a client who bought a property that was like their dream property, and they were preparing to retire, and tenant trashed it, destroyed it. They ended up getting sued as a result. And people don't realize this thing actually happens. Tenant could cause the problem and then sue you for the problem. Ended up litigating and winning, but it was several $100,000s to get to trial and get through the end of trial, and it pretty much destroyed them. And they had to sell the property, and it left a big dent in their finances they could ill afford. The wealthy tend to have multiple layers of insurance, number one, which is kind of the moat. You know, if you think about asset protection, think about a moat with a castle. The LLCs, the land trusts, or like the walls. If you can make those walls invisible, it's even better. It's like Wonder Woman's Island where they can't see it. But the insurance is the moat around it, so you can have an umbrella policy, you have your landlord policy, and you're trying to make sure that you're not coming out of pocket. A lot of brand new investors, they're not going that direction. So like they want to make sure that you do, and then we want to make sure that anybody can create Wonder Woman Island, right? We can hide our ownership. So it's not just for the ultra wealthy, right? Anybody can do this.
Anybody can do it, and should.
And let's turn this around. Like, what happens in your experience? Because you've been doing this a long time, and you work with thousands of investors, I assume. When someone doesn't do it, when someone's name is easily searchable in the public record.
Yeah, well, you get all of the liability. You're essentially out there walking with a target on your back. Like we were talking earlier about how attorneys will advise doctors, don't tell them you're a doctor, because they just assume you have money. So if you get in any type of accident, or you're a property owner, even if you only have that one or two rentals, you own property. That is something that a lot of Americans don't have. And so they look to those people as having money. And so where my husband used to grow up in California, the millionaire dress code was just a black t-shirt and jeans, because you want to be that millionaire next door. You don't want to be the person that is flashing it around, because you really do become a target then.
So then what are the big benefits of getting your name off of title?
Well, if you're not on title, then you can think about the anatomy of a lawsuit. If something comes up, and even if it originates with one of your original property because you're a landlord and it's a tenant issue, that tenant's going to go to an attorney. And that attorney works on contingency, meaning that they front all the costs to bring the lawsuit because they're going to take on the back end 25, 30, 35% of whatever settlement, higher, sometimes higher, whatever settlement, if you're lucky enough to settle, or whatever amount the court awards at the end of the day. And so they're only looking for the high ratio lawsuits, right? If they go and they do an asset search and your name does not come up anywhere, are they really going to want to front all the money for what is potentially not a very serious injury? No, I'm not putting my efforts as an attorney into that situation. But if I look up somebody's name and I see real estate, I see paid off real estate, I see multiple properties, then yes, I'm going for it.
Now, what about an example? So you just mentioned a situation where somebody was looking at a frivolous case.
Mm-hmm.
What about knockdown, drag out? Like, there's liability.
Oh, yeah.
Have you ever seen a side-by-side where, like, you could just see in a single case somebody who has invisibility, who has anonymity, and somebody who doesn't?
Yeah, we see this all the time, especially between family members who have partnered in some sort of business venture or property ownership, because typically the younger generation will come to us, we'll get them set up with an asset protection structure, we'll have LLCs, corporations, land trusts. They're essentially become invisible investors. And then they're partnered with maybe an older, in this case, I'm thinking of, it was a younger guy. He owned nightclubs. And so he ran the nightclubs, high liability situation. One night, 2 kids leaving the club, got hit by a drunk driver, pinned up against the wall. Unfortunately, that driver was also a patron of the club. So instantly that nightclub owner is pulled into the litigation. Obvious liability there, but in the debtor's exam, where they're coming in and they're trying to figure out, okay, well, what assets do you have available to pay for this lawsuit? They couldn't find anything in his name. So he ended up being able to settle for his insurance premium, his insurance maximums, right? His dad owned the buildings, and his dad, even though they had sat together and he had said, you need to be doing this, Dad, this is going to protect our investments, what you've been working for his entire life. His dad didn't do it. He said, no, I'm fine. I've been fine. Everything's going to be fine. They did an asset search on Dad and found over $5 million worth of real estate just in that one city alone. Dad actually owned all the buildings that the nightclubs were in. What did the building have to do with the car accident?
They always sue the landowner.
The landowner's always going to get sued. And so when we like to say, when an accident happens, who do you sue? You sue everybody, right? And in a lawsuit, you actually don't even have to know the names of the parties when you file the lawsuit. You can simply put John and Jane Doe 1 through 99. And as you do more discovery, you can add those people in. And that's what ended up happening to Dad in this situation. As they did more discovery, as they found out who owned the property where the nightclubs were, Dad got pulled into this. And in the end, he said, well, my son got a deal. I want that same deal. And he didn't get that same deal because his name was on every property that he owned. So they knew he had deep pockets.
So it seems unfair.
It's
right?
completely unfair.
So in that case, Dad was in there for what, 4 or 5 years of litigation and 7-figure out of pocket.
Oh, yeah.
And the difference between the two was they couldn't see what son had. So they assumed, hey, we're not going to take the risk of spending a bunch of money to go to trial, to try to break through the insurance policy, to exceed the insurance policy, which a lot of times what they're doing is they're master of their own pleadings. And they said, okay, with son, we'll just take the insurance. With Dad, they said, nope, there's stuff to lose, so we're going to make you come out of pocket.
Yeah, they target him. And we see this, I mean, you think about 10-car pileups on the freeway where maybe you're the person in the middle. You stopped in time, but somebody behind you hit somebody behind you, and then now all 10 people pulled into the lawsuit because the person in the front hurt their neck. And we've had clients who they're one of those 10 and they get dismissed early on because they do that asset search and it looks like we're not going to waste our time with that guy or that girl. We're going to go after the person with the deep pockets.
And I just want to make sure, I'm going to throw you a curveball here a little bit. But so when somebody's doing an asset search, they're just looking to see what names in the public record. And so what you're talking about is getting your name to where it's not in the public record.
Exactly.
But it is somebody else or it is something else.
It is typically something else, or it looks like it's somebody else. And so how you set that up is going to be really important.
And we'll get into that in a second. So does this reduce lawsuits? Does this just make them easier to settle? What does this ultimately do for somebody?
This is going to be both, because if you think about the situation I talked about earlier where the attorney doesn't want to put their resources and time into a situation where they don't see a big payout. There's no pot of gold at the end of the rainbow. That's what that anonymity is giving you. Maybe they don't go after you at all. Maybe they send that person out the door because it is a frivolous lawsuit. And then once you're in the actual litigation, like the example with the nightclub owner, if you don't have any assets, there's nothing for them to go after. So they're more likely to settle for just that insurance.
So we're not talking about doing anything illegal, right?
Oh, of course not.
Right. This is just about reducing your exposure for, unless I want to disclose information, somebody can't go find out what I have. And just making myself a harder target to see, is that it? All right, now let's talk about how you actually do
It's kind
this.
of like what they say when you're getting attacked by a bear. You just have to be faster than the person you're with.
It's just, that's
You
horrible.
just have to be more invisible than the other guy.
You want them, hey, they have a finite amount of time. These billboard lawyers, they're not in the business of suing people, getting judgments and not collecting. They're in the business of getting paid for their clients, for themselves. If they don't know they're going to get paid, what are the chances of them going through the exercise? And so they're going to limit themselves to insurance and say that's it. But if they know they're going to get paid, hey, if I go all out and you have $5 million of real estate in your name, I'm going to come after, everything. Or if I see that you own 2 or 3 properties, even if you're not wealthy, like maybe you have encumbrances on them, the perception becomes you're a tasty treat to that bear. And that bear might pick you up and chew on you for a little while. We don't want that.
No fun.
All right, so let's talk about how you do this. So you mentioned things that you might title it in. Is this land trusts? Is this LLCs? Is this a combination of the two? What are we really
It's going to be a combination. So we like to use land trusts. That's for land. So we're putting real estate into these trusts and set them up in a very specific way so that it doesn't look like you own the property, but you still 100% control the property.
Okay, so explain that. Why don't we start with, what is a land trust?
Sure. So a land trust is just an overarching term to describe a revocable, meaning you can set it up, you can amend it, you can revoke it. Grantor, meaning that the people who are setting up the trust are the beneficiaries of the trust. It's a revocable grantor trust that holds land. So land trust. There are subsets of land trusts that we draft. For example, we draft a specific one for your primary residence that is designed to maintain any type of homestead exemption or tax benefits that you might have. And then generally we're using the land trust for any rental properties. And so they're a trust just like your living trust. A living trust is also a revocable grantor trust. There's 3 parties in any trust. There's the trustee, that is typically who manages and controls the property. And so for your living trust, that's your name. And that's the name that's going to show up on the public record. And then the trust, within the trust agreement, there's a grantor and a beneficiary. So if you're looking at your living trust again, that's yourself. So my living trust is the Amanda Wynalda Living Trust with Amanda Wynalda as trustee. I get all the benefit of the assets within that trust. So what we want to do with our land trust and our personal residence trust is not be the trustee. We want to replace that with either a nominee trustee or maybe even an LLC trustee so that it doesn't look like we own it. And then that trust agreement that still states our name, that says that we have all the power and that we own it, that's not recordable or searchable on the public record at all.
And so who is actually in control? Who has the power over that property? So if I transfer into a land trust, am I giving up anything?
Well, it depends. So if you go to any attorney out there, and you say, hey, I want to set up a trust for asset protection, first of all, they're going to typically say, well, trusts don't give you any asset protection. And then they need to know how to set it up correctly. So the way that we do it is that we give all the power to the party that isn't showing up on the public record. Most of the time, the trustee is going to be in charge of investing the asset, managing the asset, the duty of care, the fiduciary duty to keep the asset for the benefit of the beneficiary. The way that we set up our land trust, because you're using a third-party trustee, is to retain all of the power with you as the beneficiary in the trust.
And so in your case, are you using an attorney as the trustee? Are you using an LLC as the trustee?
We provide a lot of options. So those are two of them. We have attorneys at our firm that their name will show up on the public record. So if you search their name, it looks like they own thousands of properties. They actually own none of those properties. And do they get to control them? No. They have, per the trust agreement, they have no power to do anything unless the beneficiary asks them to do it in writing. So you, as the property owner, the ultimate beneficial owner, still retain all the power. A trustee LLC is a great alternative if you didn't want to have another individual person's name. The trustee LLC will set them up in a state like Wyoming, where the owners of that LLC are not searchable on the public record, and then you have even more control in that sense, because you, as the manager member of that trustee LLC, are then the one actually managing as the position of the trustee.
All right. So if I heard you correctly, you're holding the property's title in the name of the land trust. The land trust, let's call it the ABC Trust, acts through a trustee.
Correct.
And the trustee's name is who's actually on title. And that trustee could be an attorney.
Could be an attorney.
Or it could be
an LLC that you set up that nobody can tell you own.
Red Dog LLC. Nobody knows who the owner is, and it's sitting there as a trustee on a property in the name of ABC Trust.
Exactly. So if somebody looks up, if you own that property and it's a rental and your tenant has an issue and they look up who owns that property, it's going to look like it's a trust managed by an attorney, or it's going to look like it's a trust managed by a company a trustee company. They're not going to be able to connect it to you as an individual.
And so if you're suing me, or you're thinking of suing me, it's like, hey, here's Toby out there. You run my name through the public record. My name's not going to show up on that at all?
Not at all.
And so they don't even know I have it.
They don't know you have it. And even if you use your trustee LLC for multiple properties, that doesn't indicate that those properties are owned by the same person. It indicates that those property owners hired the same company to act as their trustee, but who's ultimately liable for anything that happens with that trust is going to be the beneficiary. So if the trust is sued, it's the beneficiary that's liable. So when I'm looking through to see if I want to sue that trust, I want to know that the beneficiary has deep pockets. And if I can't see who the beneficiary is, you're essentially invisible.
All right, so let's go there then. So now I'm suing. Let's say that somebody trips and falls on a property and it's in the name of a trust. And they don't know who these beneficiaries are, but they sue. And they're going to come after the beneficiary. They're going to come after the beneficiary. How do you protect yourself?
Well, this is where the land trust that we set up differs from what you might get out there with just any old attorney, is that you have to assign the beneficial interest over to the LLC. So that's where the trust that gives you the privacy is then combined with the limited liability company that's going to shield or sequester that liability within that one LLC. So we set the trust up originally with your name on it. That trust is not recorded anywhere, so nobody sees it. You have a third-party trustee that shows up on the public record, and then we assign the beneficial interest to that LLC. So if the trust is sued, that LLC is ultimately liable. What else is in that LLC? Nothing. And it's separate from all of your other assets, all of your other properties. So you've isolated that liability in the same way that you would if you put your property directly into an LLC.
So if somebody out there is saying, hey, my attorney told me to own my property at an LLC, you're still kind of owning this property in an LLC, right?
You are.
But let's say I had 10 properties in the same city. I could put each property in its own land trust and assign those to 10 different LLCs or one different LLC if I was willing to take that risk. But nobody would see that?
Nobody would see that because the trust agreement itself is not recorded anywhere on the public record.
Very nice. But now, my name's not on title. Do I still control that property?
You do, and that needs to be something specifically drafted into the trust agreement itself to state that the beneficiary, either you individually or you through your asset protection structure, has all of the power and control.
And so, if I ask you who actually make decisions on this, it's still
you as the ultimate property owner. And another thing that we like to put into our land trust is that a provision that the trustee is actually not allowed to disclose any information regarding who the parties in the trust are. And this is really important, and why it actually helps to have an attorney be your trustee or have your own trustee LLC. Also, a mistake that a lot of people make will be to say, oh, well, I want to save some costs, so I'm just going to have a family member be my trustee. Well, number one, Google knows who you sat next to in third grade. I mean, you literally go onto Facebook and tell everyone who you're related to. So if this person has the same last name as you, it's not hard to follow those breadcrumbs back. But that person, if they're not an attorney, they don't understand their responsibilities based on that position. So if the trust says, hey, trustee, you can't disclose to anyone, if you've got grandma on as your trustee, is she going to know that? We actually had a client who was a young man, and he wanted to use his grandmother, and we said, hey, everyone's going to know that. He said, no, she has a different last name. She's not on Facebook. She's too old to know how to use it, so nobody knows that she's my grandma. Well, the trust ended up getting sued. Who is served when a trust is sued? The trustee. So someone walked up to grandma's door because she wasn't anonymous, served her paperwork. Grandma had a mild not a real heart attack, but was upset by that. And then the attorney just looked her name up in the white pages. Grandma still had a landline, was so happy that someone was willing to chat with her about how well little Johnny was doing in real estate that she just spilled the beans about everything he owned to that attorney who was just calling up a nice little lady on the phone. So who is your trustee is actually one of the most important decisions that you have to make in this situation.
All right. So use a professional, licensed professional, or use an LLC where it's going to go through.
That you own and control.
Yeah, because even if they sued, they would end up having to sue that trustee.
That LLC.
Yep, that LLC, which is going to go through a registered agent, which keeps you from having, you don't want your birthday party to be interrupted with a process server.
No. It's not the fun kind of getting served.
So I have a two-part question. Yeah. So is a land trust ever good by itself?
Not really. So there are certain states that have actual land trust statutes. So Illinois, Virginia, Florida. To be clear, when we're drafting a land trust in Illinois and Virginia, we're not drafting underneath that statute. We're purposely under a different statute because specifically Illinois, if you hold property in a land trust drafted under that statute, you actually have to record the trust. So we're drafting outside of that statute in that state. Florida is unique because a land trust has some asset protection. But if you think of it, asset protection as a two-way street, the asset protection in a Florida land trust only goes one way. So it protects one way, but it doesn't protect the other way, meaning that if your property's in a trust and you're the beneficiary, the trust is sued, you as the beneficiary, your other assets are protected. They can't pierce in through you as the beneficiary.
This is in Florida only.
In Florida only.
Yeah, everywhere else, it's like you're
right.
You got to make sure.
So you would be protected from a tenant suing. The problem is that street only goes one way. So your property is not protected from someone suing you. So you're out there, a little liability magnet, driving your car. You're in Florida, so who knows what you're doing. Florida man lives out there. So if you're sued individually and you're the beneficiary of your land trust, they can reach into the trust and get that asset. So you still, even in Florida, want to combine it with an LLC.
And so that's where the LLCs come into play, is to isolate the liability, both the asset from you in everywhere but Florida, but also you. So if you get into a car accident, they don't go take your property away.
Yeah.
All right. And that makes sense. Are there any states that we can't do this in?
No. So ultimately, a land trust, a personal residence trust, they're a revocable grantor trust, just like your living trust. And I like to tell people, laws are any law out there, from criminal law to traffic laws. They're designed to either encourage or discourage behavior. And so we want people as a society to do estate planning. We want people to have living trusts. We don't want them to go through probate. That is expensive for individuals. That is expensive for municipalities. They have to pay for courts and courthouses and judges and court staff. So we make it easy as a society to put your property into a revocable grantor trust. These laws are designed to have them put into your living trust, but then they also qualify for putting them into your land trust, your personal residence trust. So you can do this strategy in every state. And because of those rules, it's often free to transfer your properties in situations where you may have to pay maybe a transfer tax or a dock stamp fee. If you were transferring into an LLC directly, maybe your state would even reassess your property and jack up your property taxes. The land trust can also solve that problem because states won't do that when you're transferring to a revocable grantor trust.
All right, so now we know. Use this in conjunction. The states want you to do it to a certain extent. So let's talk about a couple of things. Number one, what are the biggest mistakes people make in your experience? Because you've been doing this a long time, thousands of folks. You got to see people kind of doing the same thing over and over again. That's like, nuts. Don't do that.
Yeah, the one I already explained about using a friend or family member as a trustee. It's not you, but it's not ideal. In the good, better, and best of asset protection, it's not very good even. So make sure you're using a third-party trustee, an attorney, your own trustee LLC. Also thinking that simply setting up this structure is enough. If you don't actually take that final step and deed or transfer your properties into your structure, you've essentially done nothing. And I've seen a lot of people make mistakes at that final step that essentially what we call blow your anonymity. It's what I like to akin to tripping at the finish line of a marathon. You've put in time, energy, money, you're looking at, you can see the tape and then you just stumble, scrape your knees and you're all bloody. So having a professional who not only understands how these trusts are set up, but what information goes on a deed, so that you're not paying additional taxes, you're not getting reassessed, and your name's not showing up on the public record. I'll give an example. We even had a client from California. He had us do the deed prep, so we drafted all the deeds. None of his personal information was there. Property tax statements weren't going to his home. That's a link that people can make from the public record. And he didn't want to send them back to us to record. He said, hey, I live around the corner from the county recorder's office. I'm just going to drop them off. Well, when you record in California, and this is a nuance that people who don't do this or attorneys who don't do this every day in all 50 states wouldn't know, they give you a cover sheet. And the person doing the recording has to fill out that cover sheet in order to record. And so he put his name, his phone number, his address, and his email on this cover sheet for all 12 deeds. And that was recorded with all 12 deeds.
So his name's just right
there on the public record for anyone to see.
Oops.
Oops, yeah. Oops is right.
How about with the LLCs? Do they ever goof that one up?
Yeah, so the step that is very important in terms of asset protection. So once you've titled the property in the name of the trust, you have that privacy, you have that anonymity. But when it comes to a lawsuit, once that lawsuit's filed, once they've decided that they're going to latch on, once that bear has you in their jaws, you need to have that limited liability protection of the LLC. So the piece that people will often miss are those assignments. If you are the original beneficiary, which oftentimes you need to be to avoid those reassessments, if you don't assign your beneficial interest to the LLC, you have essentially no liability protection. So completing that secondary document is of vital importance.
How about, does anybody ever have to provide their trust agreement to the county or anything like that?
all the time, which is why we want to draft it with your name on it initially.
And so when you're doing that, you should not give them your entire binder. Like they don't need to know your assignments. You should just be giving them the original trust agreement only.
So the situations I've seen third parties ask for trust agreements, and I'll often say, when you're working with a third party, it's often because you want something from them. So in those situations, they're going to make the rules. So with counties, you want the homestead exemption, you want the property tax exemption. So you got to play by their rules. If they're going to give you the homestead, they want to know that you own the property, even if it's through the trust. So they'll often ask for a copy of the trust agreement. See this in cases where people are selling. The title company will ask for a copy of the trust to verify, right? And so you don't want to give your whole document packet, right? You want to give them only the pages and the documents that they're asking for. A lot of times, third parties, banks, they'll accept a certificate of trust, which is what I like to think of as if the trust is the full sports game, the certificate of trust is the highlight reel. It just hits all of the important things, and you can typically show that to prove the trust exists, who the parties are, even the assets in the trust. But a lot of times, again, third party making the rules, they want to see the full trust agreement. So county assessors will often ask for it. They don't record it, but they want to verify that it's your trust. And so that's why we originally draft the trust with your name on it. And then those assignments are a separate document that never goes out your email or your front door.
Now, you just mentioned a bank. So what about due on sale clause? Like, is this an issue? How big of an issue? And is it something that people really need to be worried about?
Yeah, I feel like this is a buzzword that gets thrown around on the internet and social media, and it's really not an issue at all. I mean, it's for the last 45 years, there's been provisions in place, the Garn-St. Germain Act, that specifically allow property owners to transfer their property into a revocable grantor trust. Again, laws are designed to encourage or discourage activity, and we want people to estate plan. So that has morphed into major lenders like Freddie and Fannie putting into their internal documentation and processes that specifically exclude transfers to trusts from that due on sale clause. And that's even extended to LLCs in many cases.
I was going to say, like, we've heard about it. I get asked this quite often, and I'm always like, I've been doing this for close to 30 years, and tens of thousands of transactions come through our offices. I could one hand, every now and again, somebody brings it up, and it's usually somebody trying to control the client for another reason.
Yes.
Yeah.
Where I've seen it, as interest rates have risen, banks have been paying more attention to ownership changes because they don't necessarily want to foreclose on your property. They're not in the business of owning properties. They're in the business of selling your loan or collecting the interest and making money. But if they can force you into a higher interest rate, sure, they may want to do that. When I have seen clients get letters regarding a transfer into a land trust, the letter initially simply asks for information, and it'll say, hey, does your trust qualify under all of these different bullet points? And a quick review of the trust, it's easy to see that it does qualify. Is this revocable? Is this created while you're alive? Well, yes, of course, I'm here, right? And so those issues, even if you do get a letter, are very easily handled and not an issue at all.
And I always think of it like this, like if I have a mortgage with somebody, it's a contract, it's a private contract. Congress actually passed a law that says you cannot exercise the due on sale in certain situations that involves a grantor trust. It's properties 4 or less units, primary residence or residence. But what that's done is it's freaked because the lenders they don't know. They just know that there's a trust. Oh, crud. So I've never had one that I've seen where it ever got exercised. The only time,
definitely not.
Yeah, I've just, so it's kind of a red herring out there, still floating around. But again, social media loves it, right? Oh, the due on sale, that never happens. It's like again, it's Sasquatch. If somebody owns property right now in their own name, what should they be thinking about?
They should be thinking about getting it out of their name.
So they can do this now. They could
Oh,
transfer. All right. So then I get my name off the public record. But it's been in my my name.
That's funny because people will say, well, it's in my name now. Somebody can just look at the previous deed. Sure. And it's been in somebody else's name before that and somebody else's name before that. And if you're in some parts of the country, it's been in other people's names for 250 years.
Yeah.
If I'm suing someone, I don't care who used to own it because that person is not responsible for what has happened now.
Yep.
Right? So we're only looking at who the owner is today. That is where the liability is going to land.
All right. Now, what's their first step to creating the invisibility, to getting their name off their property?
Well, if you want to do it the right way, the first step is going to be to type consult down below, and then we can get you set up with one of our advisors. But you want to, the things that you want to have in place, you probably want to pull if you can get your hands on your deed, and then you can actually see exactly how your name shows up on title there. And then you want to contact an attorney like us to get your trust set up. We really only need your property address and a copy of your deed, and we can get this done like that.
Perfect. So, action item, if you want to get your name off your properties, or learn more, type consult in the comments below, and we'll send you a link so that you can talk to an expert and determine whether it's something that's right for you. Amanda, anything else that you want to throw in there? Anything else? Any parting comments?
Just thanks for having me on again, Toby. This has been great. Privacy and anonymity, when you're building your asset protection structure and you're thinking about your wealth building and all of the things that you've done and the sacrifices you've made to change your family tree and build this for the next generation, a lot of people miss that anonymity piece and miss that privacy piece. And so just making it harder, blowing a smoke screen out there is so important. Yes, the LLCs, those are what I consider your bulletproof vest. But if you can get the bear to go for somebody else, that's going to save you a lot of headache and heartache, because we talk a lot about the end of a lawsuit, not having to pay. But so much of the stress, talking to people who have even been sued, sure, they come out of it unscathed financially, but their relationships have suffered, their mental health has suffered, their sometimes physical health has suffered even. And so just avoiding that and being able to put your energy where it should be, whether that's family, whether that's faith, whether that's community, whether that's building your empire, is so important.
Perfect. So like, subscribe, share this with anybody you think would benefit. And I will put a couple more videos that I've done with Amanda in the past. Go watch those next.